In this video, we'll look at Unit 12 of the Law of Torts, which is defamation. To start with, we need to define what defamation is. So, defamation refers to the publication of a statement about a person that tends to lower his reputation in the opinion of right-thinking members of society. According to the case of Mwanza versus Zambia Publishing Company, the court defined defamation as any imputation which may tend to injure a man's reputation in a business, employment, trade, profession, calling, or office carried and held by that person. So, when they say imputation, imputation means the act of attributing or assigning blame, fault, or dishonorable conduct to someone. So, where defamation is in permanent form, it is called libel, and where the defamation is not in permanent form, it's called slander. In the case of James Kamasanda versus Van Boxtel, the court stated that defamation, which is communicated in spoken word, is slander and not libel. So libel is defamation made in permanent form, such as radio and television broadcasts, public performance of plays, and statement posted on the internet. But libel is actionable without proof that its publication has caused special damage to the person defamed. So slander is a defamatory statement made by spoken words or gestures that is not in permanent form. It is only actionable on the proof that its publication has caused special damage and not merely loss of reputation. But proof is not necessary when the slander implies the commission of a crime punishable by imprisonment or infection of a contagious disease as given in section 3 and 4 of the Defamation Act. So some differences between libel and slander are that libel is made in permanent form while slander is not made in permanent form, and the other is that libel is actionable per se while slander is not actionable per se. And the other difference is that libel is both a tort and a crime as given in section 191 of the Penal Code, and while slander is just a civil wrong, meaning you can't be imprisoned for it. Now that we have defined what defamation is, the two types of defamation, we can now dive deeper and look at the elements of defamation. The first being the statement must be defamatory. So as in the case of Parmiter versus Copeland, the court stated that a defamatory statement is a publication without justification or lawful excuse which is calculated to injure the reputation of another by exposing them to hatred, contempt, or ridicule. And also in the case of Movie TV versus Katanga, the court stated that a statement is defamatory if it changes how right-thinking members of society view the victim after its publication. So now we can look at innuendos. So an innuendo refers to a subtle or indirect remark that is often suggestive and hints at something without explicitly stating it. So as was seen in the case of Mutemba versus Zambian newspaper and another, the court stated that where in their natural and ordinary meaning, words are not defamatory, the plaintiff has the burden of showing that the extrinsic facts known to a person to whom the words were published, which would cause the words to convey the defamatory imputation, on which he reveals to a reasonable person with that knowledge. So this case basically defines what an innuendo is. So we have two types of innuendos. We have the true innuendo and the false innuendo. So a true innuendo is a hidden insult that only makes sense when you know additional information. So to prove this, you must show that others know the additional information. Then a false innuendo. So this is one which a reasonable person, guided by general knowledge, would infer from the natural and ordinary meaning of the words, as was seen in the case of Hayward versus Thompson, where it was held that an unintentional reference to the claimant can still amount to defamation. So now we can look at the second element of defamation, which is the statement must be about the plaintiff. So, in the case of Mwinga versus Times newspaper, the court stated that it is for the plaintiff to prove reference to him, and this is so whether his identity has been put in issue or by the pleading or not, for unless he can prove that the defamatory imputation was published of and concerning him, he has no cause of action. So what this means is that the plaintiff must prove that the defamation was published and it was about him. If he fails to do so, then there is no cause of action. And as a general rule, a statement aimed at a group will not be considered to refer to its individual members. For a statement relating to a group, no action will stand unless the class is so small that the claimant can establish that the statements must apply to every member of the class, or if the claimant can show that the statement refers to him directly. So now we can look at the third and final element of defamation, which is the statement must be published. So a publication is simply a communication of defamatory words to a person other than the one who has been defamed. As was seen in the case of Pullman versus Hill, where the court held that dictation of a defamatory statement to a secretary or typist is publication. So now we can look at the defenses that are available under defamation. The first being truth or justification. So truth or justification is a valid defense to show that the defamatory statements were in fact true. So the defendant has to merely show that the statements are substantially true. So it will be sufficient for the defendant to show only that the truthfulness of the most serious statements, such that other statements do not materially injure the claimant's reputation. So the claimant has no right to complain about the statements that lower his reputation. It is also irrelevant whether the statements are published out of malice or so that others can come to know the truth, as was seen in the case of Banda versus Zambia Publishing Company, where it was held that a plea of justification is a complete defense to the action for libel. But to establish this defense, the defendant must establish and prove that the defamatory imputation is true in substance and fact, as per Section 6 of the Defamations Act. So the second defense we have is fair comment. So under fair comment, the defendant need not to show that his statement is true, but that he has the right to criticize the claimant. So the case of Ndovi versus Post newspapers brought out the three limitations to fair comment. So in the case of Ndovi versus Post newspapers, it was held that there are three requisites for the defense of fair comment. The first is that the comment must be an observation or an inference from facts and not an assertion of facts. And the second is that the matter commented on must be of public interest. And the third is that the comment must be fair or objective, and it should not be actuated by malice. And then the third type of defense we have is absolute and qualified privilege. So absolute privilege is a stronger form of privilege and applies on occasions where the need to protect freedom of speech is so important as to create an absolute defense to any action for defamation, irrespective of the motives or the words being spoken. And qualified privilege, so this one is a weaker form of privilege, and it applies on occasions where it is desirable that freedom of speech should be protected, but only where the author is acting honestly and without malice. So absolute privilege is enjoyed by parliamentarians and members of the judiciary. And qualified privilege covers situations in which an individual is obligated morally or statutorily to communicate information. Then the elements are that the first is that the occasion must be fit for qualified privilege, and the second is that the matter must have reference to the occasion, and the third, it must be published, passing from right and honest motives. As was seen in the case of Fungamwango and another versus Nalisheo, it was held that where there is malice, the defense of qualified privilege cannot be relied upon. So the fourth defense we have is offer of amends that is provided for under Section 10 and 11 of the Defamation Act. And so this defense applies to an intentional defamation where the defendant publishes a defamatory statement knowing that it refers to the claimant, but honestly and reasonably believing that the statement is true. So in this case, the defendant must prepare to admit that they were wrong and offer in writing a suitable apology and publish the apology and pay compensation if it is needed. Then the fifth and final defense we have is innocent dissemination. So this requires the person disseminating the information to establish that he did not know that he had and had no reason to believe that the publication in question contained defamatory materials. In other words, he takes reasonable care in relation to the publication. As was seen in the case of Fungamwango versus Nadisheo, the court stated that a person who publishes for commercial purposes cannot claim under this defense if he adopts a reckless disregard attitude towards the truthfulness or otherwise of such publication. The burden shifts to the publisher to establish the precautions it took before the publication.